So we've got Hayden from Australia, Lena from Germany, Teresa from Czech Republic. Yay, Bruno. And from that perspective, we're just going to go through various bits and pieces. So the first thing I'm going to do is throw immediately to my left for Teresa to introduce herself.
Hello everyone, it's very nice to be here. Thank you for invitation. I specialize at IP law and I'm an attorney, so usually I'm helping startups and small and medium businesses with their IP. We make sure that they have it under control and of course that they do not forget about open source licensing and the impact of the open source licenses on their products. So that's about me.
Thank you. Hi, everyone. My name's Hayden. I'm a partner at Thomson Geer, a large Australian law firm. I have a background in law and IT, and I practice extensively in the software industry, including in open source, and really pleased to be talking with you all today. Thank you.
Hi, everyone. Nice to be here. My name is Lena. I'm a partner at Osborne Clarke, which is a UK law firm, but I'm based in Berlin and specialize in open source law since, I don't know, maybe 15 to 20 years. I've been studying at university. I do code myself, so I stumbled into that quite naturally. And now I do open source and software due diligences, contracts, and licensing issues, as well as the interface to AI and new AI law and open AI. Looking forward to discussing with you.
So given that you've done some coding, and I know Hayden's written some code, how many open source projects have you contributed to?
It's 2 and it's very long ago.
And that's one of the things. We're always looking for contributors, even if they are lawyers, to be able to assist in any open source project.
Is there a test question?
No.
Are you a lawyer?
No. I suggest you don't lead with that, but it's an essential part of the industry. So what I've actually got here, if the clicker will work, that's what we put up as the abstract. From a general point of view, we're effectively going to not bore you with all of those details, but flip through a range of different things. Now, we've got a series of questions or topics that we're going to basically discuss between the panel. The concept is, we're here for you, we're not here for us. So if you happen to have any topic, you go, hey, I'd like the panel to address that, just put your hand up, somebody will bring a mic to you. We'll interrupt whatever it is that we're doing, and we'll deal with questions from the audience. And you'll get a sense very quickly how each of these 3 lawyers approach topics. So we'll sort of have a dry run of a couple of questions, and then feel free to interrupt. Now, with the light shining on me, I'm unlikely to see anybody with their hands up. That's where we've got the lovely helpers in the room to be able to detect that. So this is sort of my idea of a little bit of fun to start with. So what's the first thing you learn if you're a software developer? Well, lawyers don't really know anything about software. The concept that somebody might have a IT degree and a law degree and know how to code, you just sort of forget about those things. So in general, people don't seem to have that high opinion of lawyers from a developer perspective in terms of their usefulness. So Hayden, what's your experience, in terms of interacting with software developers? You feel that intense respect for everything that you do?
I think talking with developers is a little bit like talking with doctors or any other sort of professional. Often, they believe they know their topic very well, and I'm sure they do. But there are a couple of traps that I think are easy to fall into, including with open source licensing. And I think understanding the basics is very important, because the consequences of it going wrong, if you build a really successful product and you're at a very important part in that product's life cycle, and these issues start to bubble up to the surface, if you're in a dispute, or maybe you're in the middle of an M&A transaction, not being able to identify exactly what it is in your code is proprietary, what is third party, and of that third party content, what might be open source, and the various licenses attaching to that, I think is a fatal error. So I'll talk to some examples as to why I think that's really important throughout today's session.
So Linus, what's your experience in terms of the adoration and respect you get from software developers?
I think that most of the times they're right with their approach to lawyers, because there's not so many lawyers in the world that actually understand software development. That said, usually a good door opener is panic. Tell them what can go wrong if they ignore concepts of copyright, licensing, and stuff like that. And I've made the experience that when you talk to them in their language, talk to you guys in your language, and tell them, okay, I understand what you're doing, please make an effort and understand what I'm doing and that I'm trying to help and not to make things more complicated. It usually goes quite well. And then we can explain concepts like copyrights and licensing issues, and the importance of complying with the various sorts of open source licenses you can come across when you develop code. But the general lawyer image is not wrong, but there's a few of us, like the three on this panel and a few more in the world, that actually want to help and try to understand what you're doing.
And Teresa, what sort of view have you got in interacting with software developers?
Yeah, I think it's there are like different software developers in terms of those who know something about open source and some who do not know, or they know but they are not going to do anything with that. And you have to, as a lawyer, you have to kind of adapt to it. So find out like what your client wants and make some notifications. Here, there might be some issue, and be careful in this case and that case, and don't think that if you know what copyleft is, that you know everything about open source.
So what's more dangerous, Teresa, a developer who knows nothing about lawyers, or a developer who thinks he knows or she knows everything about lawyers? What's more difficult to deal with?
Yeah, like also, like let's say the license language sometimes is not written in a way that it would be understood by humans, but by lawyers. And there should be certain interaction between the two parties. And as Lina said, the lawyers are here to help, so please don't judge us if we don't understand the technical issues in such detail. But you will also recognize, I would say, that your lawyer, if he does know or does not know the necessary stuff about copyright and open source licensing, because he should ask you the right questions concerning the technical part to understand how the law applies to your software.
So Lina, lawyers are completely interchangeable, aren't they?
Yeah, yeah, sure.
There's no need for us to sort of do any research when we're looking for a lawyer.
No,
They're just all the same.
Exactly, just take anyone, and you can be sure that they cannot help. What I found out during the last years is that coding and writing contracts and understanding contracts is actually very similar, because it's an if-when and if-then concept. And once you've got to that point with someone you're talking to and maybe trying to clean up some code or trying to understand the interaction of various components and the various licenses, that makes things quite easy. And when you look for a lawyer, you should always ask the question, does he understand or does he want to understand what you're doing? It doesn't really matter if he's an open source specialist as long as he understands the technical basics or wants to understand the technical basics and lets you explain how it works. And of course he has to know something about copyright and licensing, but I think most lawyers that you get in touch with do that already. And for the lawyer, I would say, I'm pretty sure you guys agree, it's important that we are open for what the people we work with tell us, and that we try to explain licensing in a way that doesn't make it more complicated, because we use legalese for an hour or so, but to break things down to the exact point. Like you have to collect the copyright notices and put them together in a file or stuff like that, and not say, yeah, you know, you could say this and this could mean this and maybe it also means this, and then you can do that. That doesn't help anyone. Question?
So can we get a mic for the question?
From a practical perspective, what would be your recommendation for safe handling of open source in commercial software? I mean, things like keep track of copyright notices, check the licenses, it's okay to link, if it's GPL, it's okay to isolate to API, if it's AGPL, stay away from it. You know, practical rules that we can live by and never need lawyers actually.
Speaking of breaking things down to the exact point,
so
right?
if I paraphrase the question, could you three please explain how to put yourself out of business? So what's sort of the one or two really important things that you think a developer should know above everything else? Hayden, you want to run with that first?
Sure.
All three are going to get to talk on the topic.
That's right. So I think keeping track of your code, keeping track of what's proprietary, what's third party, and then breaking down those third parties into categories of third party proprietary. Maybe these are some copyleft licensed open source. These are some permissive open source, but having that diligence to keep track of it all and being able to produce it all, very nicely upon request to say this is the complete composition of my software, including all the licenses and third-party code that attaches to that, I think is very important, very good practice. But in my experience, I suppose as maybe a provocative statement, I think most developers in the course of doing what they do, because they're very focused on their product, often don't want to stop and really think about where they're getting their code from and the consequences of getting it wrong. So I think as a general statement, lawyers aren't so good at certain things, but equally developers, I think, often in their haste to create product to do what they want to do, overlook those details, and I think it's very important to focus in on getting that right.
So other than keep track of the licenses with each piece of code, Lena, and slow down, that's what I got. Slow down, don't go so fast. Make your boss happier by being less efficient. Lena, what would you add to that list?
Always when I get asked these questions, I always say three things. I think the first thing you have to be aware of is that any use of any software is forbidden unless you have a license and a right to use it. And if you don't find a license, go look for one, because if you don't find one, you're not allowed to use it. The second thing is, when you want to use open source software in your commercial code, you need a process in order to find licenses, check licenses, and comply with licenses. And the third thing is actually the contrary to what you said, Tim. It's giving me work. Do one big project with a lawyer and let the lawyer directly into the project and directly work with him. Because you learn so much on the job, like how licenses interact, what lawyers are looking for, what things are difficult and what are not, which components. I mean, I've seen basically every component in the Linux ecosystem at least once in my life, maybe 10 or 100 times. You learn through the experience, and then you can do the second project basically on your own, and you just have to ask the lawyer for the really difficult questions. So that's the three things. Know that you need a license, have a process in place, and do one project with a lawyer who knows what he's doing.
So I took that to mean we need to invite the lawyers to the code reviews. Is that where we're going? That level of engagement? Sure, there'll be extra billable hours.
I'm all for it. Yeah, every single code review.
So Teresa, what's your experiences in terms of developers just being disconnected, and the practical advice you'd have when you're first meeting this new startup company that's come in? They're all enthusiastic and they've done nothing.
Yeah, I think first of all, it's very important to see what product you want to create and how you would like to monetize that. That's the first thing you should consider. Because if you just use something under strong copyleft, it will just spread to your product, and then you have to count on different way of monetization than if you want the proprietary product. So this is very important to consider at the first place. It's also different when you want to use the open source components for software as a service product, because some licenses are absolutely okay for that and you don't have to do anything. Some licenses require certain obligations. So first of all, always consider what is my product and how the open source goes with that, like what are the implications, and set the rules for yourself. Make a list and tell your employees and your contractors, these are the licenses which are okay according to our product's nature, and these are the licenses we should not use. And if you want to use a new one, just come to check, and the lawyers will tell us whether it's okay or not, and whether it would have bad implications to that product.
And the tail end of that question was on the AGPL. Now, I'm going to take it that lawyers love the AGPL because it's extra work. It gives you more business. So, Lena, you've got some experiences with the AGPL and it helping the law firm meet its commercial targets for revenue?
That's what it usually does, because no one actually can comply with the AGPL. I think there's another question, Tim. Should we take that first?
Yeah, hi. Thank you very much for being here. And, well, for the record, I, for one, welcome our new legal overlords. A good technology lawyer, you know, is like a set of racing tires on a road bike. You don't know how easy life is before you get one. But
Wow.
now, when we talk about all the software licenses and everything, we are assuming a fairly static model of software. But when we look at, for example, any software product which is, say, certified under NIAP in the US, or anything that meets the CRA requirements, it's continuously changing. You know, we have to provide the SBOMs, and all the software components will have to be continuously updated. The developers are obliged to make sure that they are. So how do we prepare for this continuously changing sort of software components in our product?
Who wants?
I'm happy to take a swing. The nature of software development, as I understand the question, is the nature of software development is not static. At the composition of our code bases, the licenses that might be encompassed in that code base or relied upon by reference in that code base is constantly therefore changing as well. It's a very complicated task. And to be honest, there's no easy answer to make that hard problem easy. But I think having a really good systematic process in place, you know, maybe linked in with the sort of continuous integration, continuous deployment process of a code base, something that really, you know, links that in with the life cycle of you know, a CI/CD process, I think is really good. And having those checks in place to say what's changed, what's the delta. Involve lawyers in that, because just as you would involve other developers to do a cross-check or a peer review over this new deployment you're looking to do, not only from a developmental code perspective, but also from a legal perspective, because it may be that in this new deployment we've introduced this new type of license. That new type of license, you know, maybe isn't adequate or isn't well adapted for the nature of the product and what we're going to do. Often you see products which have taken you know, a legacy on-prem product and then going into a cloud deployment, and they might be presuming that what happened in the legacy on-prem will be the same in a cloud deployment. But certainly if we're using something like AGPL, to go back to that comment that Tim made just before, that is not the case, and it will have significant implications for the proprietary nature of your product if you're not taking those methodical steps as you go through your deployments.
So be methodical, work harder, pay more attention, don't make mistakes, bring your lawyer in. What about using things like automatic scanning tools to help in the... You've got some experiences with that, Lena, Teresa?
One of my clients is developing one of those tools currently, but most of the startups, they do not use it.
Yeah, I think the automating processes as far as possible is a very good idea, and delta checks in regular intervals, depending on the project, right? If it's an app, you can do it every month or once a month or every 3 months. If it's something critical, you should do it more often. If the software is very dynamic, do it every 2 weeks or even once a week and have the delta checked, just the delta. That's how the industry works in most places, and it actually, I haven't seen that go wrong, which is a good thing to say for a lawyer. Exactly, and making no difference, picking up on what you said, Hayden, there is actually no difference license compliance-wise between cloud software, software as a service, and actual on-prem or embedded software, because you need to check the whole code base. If there is one license that's not good, if there is an AGPL in your cloud software, you have to find it out and you have to comply with it. And if there's 27,000 MITs in your embedded software, that's fine, but if there's one GPL, you have to comply with it. So it doesn't make a difference when the software is made available to third parties, you have to check it, and there is no difference.
Absolutely.
So if we haven't got any other questions from the audience there, we've got another one down the back. Oh, here comes trouble. He's in a purple shirt.
So, first of all, thanks very much for the statement by Lena that I didn't know personally, like that you have to know the license of software before you use it. But basically, to me, that means you just destroyed anything that's around AI code generation by GitHub.
Yeah.
So, for open source contributions, how do we deal with that? Because we don't know as reviewers, for example, where some code has been generated, where this is coming from. How do you deal with that?
There's an easy way that is like 95% sure, and there's the complicated legal way. The easy way is scan the output of your AI tools with an appropriate snippet scanner, like the expensive one, and try to find out what's in there, because you cannot be sure what's in there. And you do not know how the model was trained, you do not know where the code comes from, so you have to actually do that. It's just the same with human-generated software. The complicated legal way to put it is there is no safe way and no 100% elimination of copyright infringements in any code. It's more dangerous with AI-generated code, of course, because it's automatic and there's less human influence. But with human code, it's the same. No one checks every line of code he writes. So the answer is always the same. You have to scan your output and try to find out what's in there.
So Teresa, you've been getting the AI questions as well in your practice?
Some of them, but like usually the clients, they are just using the AI without asking. That's the most of the cases. And what they care about is like, is the output from the AI tool copyrighted? That's the usual question. And usually it's linked more to like different contents than software code.
Okay.
So the developers, they do not ask, rather.
Right. So the practical advice I get out of that is if you're using AI-generated code and the AI is trained on GPL code, don't tell your lawyer. That's the advice I should have got, Hayden?
Yeah.
Sure, because follow that advice, because it'll come back to the lawyer at some point in time. But having said that, the issue around AI-generated source code, I mean, it's an incredibly vexed one. It's untested before the courts. We don't have actually guidance that I know of anywhere in the world that sort of looked at this specific issue and given guidance. But we just go on, base principles here that the LLMs are obviously sucking in all available data to train the algorithm, and often a good source of source code to train it will be open source. Yep. And you can guarantee some of that will be some copyleft license code. So it's a really tricky issue, really hard. But one of these days there'll be a case where someone with enough money takes on someone else also with a lot of money, and there will be probably a settlement because it's almost like mutually assured destruction, much like you see some of the litigation afoot now in like the Getty cases and whatnot, where image right firms are taking on some of the big AI providers. We will see that then step into software at some point, I have no doubt.
And lots of happy lawyers.
Yes.
That happens. So you're trying to sort of generate the context. So the AI side of things seems something that's fairly vexing in terms of no clear way to deal with it at the moment.
I would like to modify your statement of earlier. It's not don't ask your lawyer, but it's don't ask your lawyer for a written statement on that. Because there is no lawyer in the world who can actually say this is clean, there's no copyright infringement in that. The line is always, it's very likely that there is no copyright infringement, and that, at least under German law, I don't know how it is in Australia and the Czech Republic, but under German law, this can mean that you're in some sort of culpable behavior if you still use the code, and that makes you liable. So you wouldn't want your lawyer to write that down.
That's right. You will get into some sort of authorization of infringement type sort of argument, likewise in Australia as well.
So that's one of the if your lawyer offers you this, choose another lawyer context.
Before he
that
sends you something.
It seems that fundamental. There's certain practices.
It actually is. It actually is, and it's a mistake we often see, and a lot of colleagues are not aware of if they're not specialized in copyright issues. If you write your client in the wrong wording, that there is a potential of infringement if they use the code, the book, the text, the picture, whatever, that might mean culpable behavior on the side of the client, because he knows that there's a potential of infringement and he still does it. And it always depends on the single case, of course, and you have to look at all the circumstances, but there is a risk. And that's why I tend to say, okay, let's have a call on that, let's discuss what the issue is, and then decide what the work product that I deliver can be, so that it helps you and doesn't put you in more shit.
So that's why lawyers like to do everything by phone instead of via email. So there's no record,
I hate
nothing
being on the
discoverable.
Even lawyers like disclaimers.
Lawyers like disclaimers, yeah. It's kind of interesting from that perspective. So if there aren't any other questions, and if you've got a question, feel free to bring it up. What about this one here? How many times have you run into a developer who thought they could work around a license? I've got this clever idea. If I just do this, the license won't apply, and then I can do anything I like.
Yeah.
How frequent does that happen?
Very frequently. Yeah, I think that there's a perception that, developers think, developers are problem solvers, and we'll throw a problem at you, legal problem, and be like, I know the answer to that. I'll just take this open source code and I'll put it just over here in this module. Yeah, it'll all be incorporated. It'll all be compiled together. There'll be no problem, right? Because it's separate. It's a separate module, or maybe we'll link it in some particular respect. And look, there is some nuance as to whether the degree to which open source might be linked may cause it to not be such an issue, but certainly I've never met a developer that thinks they can't program around the problem.
Well, it's actually programming around needing a lawyer in reality. So Teresa, what sort of things have you seen? Like overly clever developers, or has this never happened to you?
It happened to me, and like the developer was actually thinking, how did my competitor do it? That they are not sharing the code, and we don't want to share the code. There was a copyleft license linked to it. It was, I think, GNU GPL version 3, and it was clear they should. And they were trying to get out of it. I don't know what was the technical outcome of it. Like my advice was, this is not safe. You would be in breach. But I rather did not investigate the result.
Because you don't want to know the answer for the previous reasons we just talked about. So, Lena, you've experienced this as well? I can see from the smile on your face, it's like you're thinking particular incidents where this has occurred.
It happens actually quite frequently. I think everyone in the room knows what a wrapper is. And people use, we as lawyers call it the LGPL wrapper. They put some LGPL stuff around their GPL stuff, thinking that would like stop the copyleft, which sometimes even is the case, but in most cases it's not, because the LGPL has another copyleft and it doesn't really work with the GPL. Yes, there's a lot of developers who think they can outsmart the license texts. I usually try to explain to them, look, if you were the developer and you put your code under that license, would you want other developers to do that, what you're just trying to do? And the answer is always no. And that brings up a certain understanding of the problem.
So one topic we did go through in the prep for the panel, which I found interesting, is some of the law and legal differences in copyright between various countries. And I think all three of the panel members realised, oh, it's different there. So would you like to give a quick summary of some of the differences that you would see? Teresa, you want to start out?
I think one of the questions we encountered in our previous talk was actually moral rights, which work differently in each country. We were talking about how moral rights appear in employee contracts and in work for hire contracts. And in the Czech Republic, if you have employee work, you are employed by someone, you have the normal contract for employees. You do not get rights to your code. You are author officially as an employee, but all the economic rights are basically exercised by the employer. And also the employer holds the moral rights. Although it's not written like that in the law, there are certain assumptions, but it's assumed that the employer has those rights and can exercise them himself. So he can change the code, he can publish the code under his name, and so on. So this was one of the differences we've seen.
So Hayden, you want to just give a quick summary of what a moral right is, as distinct from copyright itself?
Sure, thanks, Tim. So moral rights are personal rights. They cannot be bought or sold. This under Australian law anyway, there's 3 of them: the right of attribution of authorship, the right not to have your work subject to derogatory treatment, and the right not to be falsely attributed as the author of a work. So when we have copyright, copyright in particular, if we're talking about software that's classed as a literary work, copyright is a property right. It can be bought or sold or licensed, as distinct from moral rights, which are a personal right. They cannot be bought or sold. They stay with the individual. And at least under Australian law, those rights, you can consent as an individual to having those rights infringed by giving a fairly specific consent, and that will effectively nullify those moral rights to the person you've given that consent to, and that's very common in Australian employment agreements, for example. But I understand the position is again different in Germany.
Yeah, I think Germany is like a mixture of both. We have this moral rights concept, the right of authorship, because copyright is a work under the Copyright Act, similar to books and paintings and stuff like that. And there are rights to exploit that work, such as distribution, copying, editing, making it available to the public. And you can transfer those rights to exploit the work, which you as an employee automatically do to your employer, but you can never transfer, as Hayden stated, that's the same in Germany, you cannot transfer the moral rights. A specific thing in Germany is that when you infringe a copyright because you do not have a license, you did not get the right to exploit a work in a certain way, this is a criminal offense. So you can go to jail for it in extreme cases. In most of the times it just costs money. For the developer himself who infringed a third-party copyright, and for the management of the company he works for, that also means personal liability for those managers, be it the CEO, be it the managing director, and so on. And that's what makes open source compliance, license compliance, copyright compliance in Germany particularly difficult, because you have to make sure that no one is personally liable for what they do. It's not just the company, it's actually the private person who has to pay and or pay the fines, penalties, go to jail. So that's a specialty we discovered no one of you has in their law.
Yeah, there's certainly no criminal basis under Australian law, but yeah, it is very interesting, and it makes sense why you see a number of the high-profile open source cases brought in particular by the open source licensor. Often they're initiating those proceedings in Germany, so that makes sense given the stringent provisions there.
Yeah, we have criminal liability here in the Czech Republic as well for severe breaches of copyright. It has to have certain level, because there is the rule, like if it can be resolved, the dispute can be resolved by civil proceedings, or it's like minor misdemeanor. It should not go to the court at the criminal proceedings. But if there is some intense, severe breach of the copyright, it can go to the court, and you can be imprisoned even for that, although it's not usual penalty.
Indeed, so some interesting things. I'm just going to flip through. We'll skip CLAs. What about the European Union Cyber Resilience Act? Is that the end of the world for us, or is that a really good thing, or is that just a way for lawyers to make a whole pile of extra money over the next 2 decades? Lena, you got a view on that?
Because I'm looking so annoyed. It's EU regulation. It's a huge playground for lawyers, because everything is still pretty unclear, even though the CRA was negotiated and discussed years. It feels like decades. I think it will make the work more difficult, just because of one simple fact. You now need at least 2 documents when you deliver your software. You need an SBOM and you need your mandatory compulsory statements for the open source licenses, such as copyrights, license information, and so on. And there is a number of other requirements in the Cyber Resilience Act that will make things a bit more complicated, but as with every EU regulations, we will get used to it, and we will find ways to do it in a practically not too difficult way. But there will be a transition period for the next years where we'll discuss this topic at length. I'm very sure.
And Teresa, in the Czech Republic, you see similar things to in Germany?
Yeah, well, it's European Union regulation, so it applies here as well, of course. I'm myself not a cybersecurity expert. I have a colleague for that, but even the startups will have to deal with these provisions. So.
And Hayden, because you come from the land of the free, and we're not in Europe, you're just completely ignoring it?
Certainly something to be conscious of for clients doing business within the EU, absolutely. In Australia, we have some interesting legislation which has come into place called the Security of Critical Infrastructure Act, and for any connected devices that are sold in the Australian market, you will need to have a clear list of any, similar, I guess, to a software bill of materials, so being able to really clearly articulate the constitution of your software work, where it's used within those regulated connected devices which might be used in a critical infrastructure asset.
It's just providing all the information a lawyer needs to be able to find who to sue. But basically, it's a starting point for a whole pile of fun and games.
There's one more EU regulation that will be a lot of fun for software developers. That's the new Product Liability Directive, because software as such will be a product very soon. And even though it has an exemption saying that source code is not a product, where does source code start? What is source code within the meaning of that regulation? And how do I make a difference? Right? So that's the questions we will be discussing in the next years as well.
But I had heard that the EU, speaking of EU regulations and sometimes their excesses, I heard the EU is winding back their cookie banner requirements. Is that right?
Yeah, that's true.
There you go.
But they used like 4 different open source definitions in 4 different regulations. So
Lots of fun. We'll skip other regulations. We'll skip that. Combined licenses. I think we can skip through that. We could skip through that. So what about de minimis? It comes up often. It's like, it's too small for anybody to care about. How much trouble do people get themselves in with this? Lena, you want to take a run at this? It's too small to be concerned about.
Just sign. Yeah, there's no such thing, right? There's no way to exculpate yourself by saying it's just too small to care about. And it never is small when you consider the amounts of money that have to be paid to clean up even the smallest code mess. It's always expensive. So there is no de minimis in software compliance.
Absolutely. I mean, if you can think about if you've got a product out on the market and there are millions of customers that you have using this product, you might have a fairly minimal piece of code that could have caused an issue. Maybe you've gotten into a dispute with the licensor, be it an open source licensor or otherwise. They've terminated that license. Taking that product that's out there in the market for 1 million customers is going to be hugely disruptive. So even those de minimis problems can be very large indeed.
And Teresa, sort of the final comment, because I think we've hit our time here.
Yeah, I have one criminal case myself, which is about breach of the GNU GPL version 2. And the breach was, or consisted of complete removal of all copyright notices in the code. Although the perpetrator, he was sharing the code further, he changed all the copyright notices. So this could be a small thing at the first sight, but it's not. So it's now with the police and under investigations of how big damage arose and how many cases of breach there actually happened.
Okay.
Do we have time? There's a question there, I think. Okay.
So Marcel, grab the question, find any of these lovely people.
We'll be around.
We'll be around.
Yeah.
Pretty easy to identify. Just the old lawyer, and there won't be too much of a problem from that perspective. Thanks, everybody.